Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law Section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners curious about these topics and what the experts in these fields have to say. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Trial Practice Committee of the Antitrust Law Section. Today's episode is 7 tips for trial attorneys for putting on an expert witness. This season, we've talked a lot about changing approaches to antitrust policy, but to effect change, you have to win in court. And a key part of any civil antitrust case is the expert witness. Done poorly, an expert can lose your jury or confuse the judge. Done well, an expert can be a critical part of winning a case. So we thought it would be fun to get a couple of veteran prosecutors into the studio to share some tips from decades of experience on gaining an edge in the courtroom when putting on a witness. Today's practice pointers are drawn from a trial academy that's run annually by the New York State Bar Association. And whether you're a junior attorney preparing for your first ever trial or a more experienced practitioner looking to refine your approach, I think there's going to be something for everyone in today's episode. Joining me today are my co-hosts, Chris Young, a partner at the Joseph Saveri Law Firm and a vice chair of the Trial Practice Committee, and Kathleen McMahon, an associate at the Saveri Law Firm. Welcome, Chris and Kathleen.
Thanks, Anant.
Thank you for having us.
Sure. Kathleen, who are our guests today?
Yeah, our guests today are Stephen Tugander. Besides being an experienced trial attorney, is the acting assistant chief of the Department of Justice's Antitrust Division's New York office with deep experience in criminal prosecution, as well as Bob Hubbard, assistant attorney general in the Antitrust Bureau of New York Attorney General's office. And a disclaimer, the views expressed by Steve and Bob are their own and not of the Department of Justice or of the New York Attorney General, respectively.
Excellent. Thanks, Kathleen. So we've got 7 trial tips here, and tip number 1 is reps are important. So I think preparation is always key, and antitrust trials are rare, so it can be intimidating to younger attorneys or even experienced lawyers who have never done a trial before. So having experience in controlled environments such as mock juries can keep those skills honed. So Steve and Bob, what are the best ways to get reps in to prepare for presenting an expert in a trial?
Well, Chris, I think I could take this first, and then I'll switch over to Bob. You know, from my perspective, you really can never do enough practice and have enough reps. I think, like with any other witness, you've got to sit down and have multiple Q&A sessions, as we call them. Got to get the flow, be on the same page as the witness. Whether it's an expert witness or a lay witness, you still have you both in both situations you have to both be on the same page and be able to understand each other. The witness has to understand what questions you're going to ask at the trial, and the lawyer has to understand, what the answers are going to be. With respect to mocks, I think a great way to do that is through formal or informal mocks. You want to get a sense as to how the witness is going to look, how the witness is going to feel comfortable in front of a jury. So to the extent you can get people in your office, outside people, people from formal jury consulting firms to provide an audience for a mock presentation and to critique it and to get their answers, the better it's going to be when you actually go to trial.
Yeah, no, and I think an antitrust expert is more of a challenge than most witnesses. I mean, I think that a lot of antitrust attorneys tend to think of an expert as a magician who will, testify and convince the jury that the position that the party takes is correct. I think it's much more important to understand what the expert is talking about, probe it, translated into terms that are understandable. I think all of that is possible. And if your non-lawyer sister or your mother or your daughter couldn't understand it, then you ought to think about how you can make it into language that works. And as Steve said, that takes practice. That takes work to understand what the simple message is, how you can convey it, and how it can be understood.
And Bob, can I ask a follow-up question
Sure.
off of that? What are some ways that you can make it more digestible for a layperson when you're prepping an expert witness?
I've always, I think there's lots of ways that you can do that. Um, uh, for example, you think about what would happen for me if I got on the elevator on 20 and the attorney general was in there and I had that amount of an elevator ride to explain to her what our expert would say. Now, that those kind of constraints and those kind of importance, I think, helps you think that through. I, for years and years and years, used to think about this. What would it take for my mother to understand? My mother's getting up there in years. I don't know that she's the best model at this point, but in any case, it is quite useful to, she's on my side. She wants to understand. You have to give the jurors or a judge that's receptive to your argument the ammunition to understand it. And I think that sort of helps in explaining to it. As a multi-state enforcer, I interact with a whole slew of people who were doing criminal work, not much antitrust, but just got a job in an antitrust bureau. And I've had the benefit of having to explain to those people what things are about. I think all that is a process that helps you understand and simplify things so that it's understandable to everybody.
And Steve, Bob, do you have a rule of thumb that before trial, run through the expert's testimony at least twice in a full-on trial environment, or is that too hard to do?
I think even more than twice, Anand. I think, again, as many times as possible, especially with an expert, there really needs to be that flow, because sometimes lawyer and expert are not talking the same language. And going to Kathleen's question, I think, breaking it down, to adding to what Bob said, breaking it down into small pieces, baby steps is a good way to look at it. And I think anytime an expert is using a term, you have to make sure that expert is explaining the term. So you have, I think, go back and make sure if that term seems like something the jury may not know, although us as lawyers or us as antitrust lawyers, looking at this case, this investigation for a long time, you certainly want to make sure that no terms are being used that are going without explanation. And the one other thing I'd want to add too is let's not forget about cross-examination. So when you're doing your mocks, you're doing your Q&As, informally in pretrial prep, we spend a lot of time on the direct, but sometimes the crucial part is the cross. So to make sure to do the cross, and sometimes what's done in legal offices is, or in the government, bring in somebody who's not necessarily the same person that's doing the direct to do the cross, because sometimes it's difficult to cross-examine your own witness when you've built up that rapport, built up that relationship. So you bring somebody else, maybe from the office, who can get up to speed and do the cross. That could be very effective.
And Stephen, I have a follow-up question off of
Sure.
what you said earlier as to when perhaps you and your expert are not on the same flow. How do you kind of bring that back and make it more cohesive so that you two are on the same wavelength?
Yeah, I think it's a great question. I think the only thing is really just to keep practicing. I think, like with any, whether it's a lay witness, an expert witness, you just have to keep going back and forth. To the extent that you put out your questions and you hear, as a lawyer, you put your questions out there, you hear the response. A lot of times then you'll go back and revise your outline so that, you ask the question that gets the response that you're looking for. So it's really just a lot of trial and error. And listen, at the end of the day, both sides have to trust each other. You've got to trust the expert has to trust you. Feel like you're on the same page. And a lot of times I think it's a learning experience, from the lawyer to learn what it is that the expert is saying and to make sure, it becomes our job to ask the right questions that elicit the right responses.
Right. And there's a lot of stuff that goes before the first mock, obviously. You want to talk with your expert. You want to understand them. You want to have, make sure you understand what she or he wants and what access you can provide, and make sure that that all those, your understanding and his or her understanding is enhanced as you go. Your mock is pretty far down the line in terms of getting to know your expert, getting to know where they're coming out, where they identify issues that they deem important, make sure you understand them, and there's a fair amount of work that comes long before any mock.
So I think that actually brings us to tip number 2, because it's not just the lawyer understanding the expert understanding the lawyer. The jury needs to understand the expert too. So humanizing your expert is a very important skill to develop when you're preparing to present an expert. So generally, people listen to people who are authentic and likable, and this is just as true for expert witnesses as for lay witnesses. So, Steve, Bob, why don't you give us some effective techniques that you've used to humanize your experts in trial?
Yeah, Bob, I guess I'll go first. I'll turn it over to you again. I think it's very important, first of all, to have the expert speak as much as he or she can, in English and not in economicsese or legalese. Use terms that people will, lay people will understand. And that takes work. That takes practice going back and forth along the lines that we just said. You certainly don't want your expert to be talking down to the jurors. So you want your expert to come across as somebody who, is a regular person. They're not arrogant. They're not sophisticated, although they have a tremendous amount of expertise and knowledge. But, there's somebody that can relate to the juror. So they're certainly not lecturing anybody or talking down to them. And I think, along those lines, coming across as somebody who's respectful, respectful of the judge, respectful of the lawyers on both sides. I think if expert starts to get antagonistic, let's say on cross-examination, he can kind of come across as being snooty and arrogant. And to the extent he's patient and it looks like he's trying his best to answer the questions for both sides, I think the better it's going to be in terms of coming across as a human being and being likable to the jurors. And just one more note on that. I think it's very important and again, it's the burden is on the attorney to do this, to make sure that the expert is taking his time, going slowly, and looking at the jury and explaining and realizing his job is to make sure that the jury gets these important economic concepts. So he's patient. He's a teacher, and he's kind of like your favorite professor in school. But it's at the end of the day, it's truly all about trust. So I think these, using these techniques will get the jurors to trust your expert.
And I have a follow-up. Oh, go ahead, Bob.
No, I was just going to say, with an expert, you want that expertise to show. And the challenge is to, have that personable style, illustrate that the expertise has been earned and it's understood and it's going forward. You should not. There are limits to the extent you should. You don't want to make him be somebody you want to have a beer with necessarily, but you do want to make sure that it's understandable, that it's going forward, that they will, elaborate when appropriate.
Thank you. My follow-up is for you, Stephen. So how do you deal with it as the attorney if you do kind of have what you described as an antagonistic expert? How do you kind of ring them back in and make them more humanized?
I think you would if this happens at trial, you'd have your opportunity on on redirect. And unfortunately, you're not always able to work with your expert or any witness after they've testified on direct, at least not in the federal system. So I think you just have to plan for that in advance. So in advance, you want worst case scenario if the expert comes across this way. And then I think just try to, use your best senses to ask him questions on redirect that somehow can get him or her to, to come across, likable the way that we discussed. But a lot of times, it's in the preparation. So I think, preparing the witness and going over it, so many times and doing a mock cross will really be the best way to prepare for that. Because I think, unfortunately, I think once that happens in the trial, it's going to be hard to bring that expert back. Although you may, I think on in your summary, try to explain, where this witness was coming from. As Bob was saying, just point out, why they are qualified. And at that point, you may, I don't know, depending on the situation, you may say, although, he might not be the most likable person, he explained this in a very, in a very good fashion, and you should believe him because, all his information is on track. But that's where I'd come from it.
It's got to be so hard, right? Like there's so much psychology into like what makes someone like someone when they first meet them that some of this just has to be completely outside the lawyer's control. And so maybe that's what you're trying to figure out through the reps is how do we limit or how do we use this expert if they're not going to come across well?
Right. No, and the thing about it is that different people behave differently. There are different experts that have, different levels of arrogance and other things. And, depending on what the topic is, other things, I know that, what some people view as adversarial, other people view as being direct, and other things, you have to sort of figure all that stuff out. And certainly you're not having the expert just be your mouthpiece. He or she is an expert. And so you want to understand that and take into account the variability of people. I mean, that's why the ongoing interactions with them, the mock and other things helps you do all that so that you can understand all those permutations and present it in as comprehensive and understandable way as you can manage.
It really sounds like the most important part about maintaining the humanity of your expert is really to keep their credibility at a high level, because just kind of teasing out some of these points, once an expert loses that credibility, it's very hard to get it back. And people generally find people who are likable to be more credible generally.
Yeah, I definitely would agree with that.
Okay, so moving on to the next tip. So I think we've kind of touched on this a little bit too. We want our experts to be storytellers and not just delivering lectures, chronologies. But what does that actually mean? What does it actually mean to have our experts be teachers in the courtroom? So Steve, Bob, why don't you tell me how you help your experts tell the story to the jury?
Well, I mean, the experts are going to come in with experience in doing this kind of stuff, so they'll have a view on it. And I found that usually it's a question of running through it and sort of responding to, making sure you understand, filling gaps, making sure that tangents aren't taken too often, things like that. And it's just the sort of learn by doing kind of stuff that we try to put into our program. You just stand up, you talk with your expert, you ask questions, you sort of figure out where they are, where they aren't, and go from there.
Yeah, I think I would just add, in terms of storytelling, I think storytelling of the expert and how he came into the case and what he's done along the way could be interesting. So for example, the expert could identify the problem that he was confronted with, that he was kind of asked to solve, so to speak. What was his process for getting there? How did he solve this problem he was asked to work on? What were the steps? Who was the team? If there was anybody supporting him or her, if they've had a big team, make sure that comes out. How long did this process take to reach this conclusion? What was the conclusion that was reached? I think if you can kind of almost put it in terms of like a scientific experiment that was being, asked to be, conducted by an expert, and he kind of reaches his conclusion that he feels comfortable with. I think that's a good story for the jury. And to the extent you can somehow weave in, why this is important, why his work is important to, to this case and maybe to the, the overall economy, I think that would get the jurors interested.
Yeah. So, Steve, what are the most important parts of preparing an expert report for testimony in front of a lay jury?
Well, I think, the expert report obviously, is extremely important. That's what he's going to talk about. I think the lawyer and expert have to work together. As Bob and I have been saying, you just got to spend a lot of time going over that report. And it's extremely important for the lawyer to understand what's in it. So I think the two of them working for the lawyer to understand what's in it, gives the lawyer an opportunity to ask the questions in that way that we've been talking about, breaking it down, baby steps, making it simple, putting it in English. But, that can't be done unless the lawyer has a very good understanding of what's in there. And as we've been talking about, when you get to the report, I think the expert, and this is a big job of the lawyer to help him or her do that, is to be able to simplify it as much as possible. I mean, you're looking at something usually that's very complicated, if you're talking about an antitrust expert and the economics that are in there. But, we can't forget, if it's a jury trial, that it's just it's everyday, ordinary lay people that have to understand it. So you got to make it simple and digestible. And I think one other point to bring out, and maybe we'll get to this a little more, if there are weaknesses in the report, if there is something that your expert is going to be cross-examined on, I think you got to confront them on direct. Bring those weaknesses out and have your expert explain why, although it's a weakness, the law and the facts and the evidence is still, on the side of this expert report.
Yep, and that's the foundation on which the story is built when they're testifying. It's not as though you're going to make the jurors read the expert report and understand it. It's a device for understanding where everybody is. So you disclose to your adversary, you push points, you see whether there are gaps. All those things are part of the expert report.
Great. So I think that brings us to our next trial tip, how to cut to the important part of your evidence. So a trial may involve many, many hundreds of thousands of pages, and really getting to the meat and potatoes of the important testimony or the important bits of the document you want your expert to focus on can really make or break the expert's presentation. So what are some techniques for engaging a jury when you're presenting documentary evidence with an expert for the jury?
I think I could start off just from the technology point of view. One thing we're fortunate to have, in 2023 is some very helpful and advanced technology. So, I've seen experts successfully explain their concepts by, let's say using a PowerPoint presentation. But, in addition to that, working with the lawyers to blow up, let's say, certain parts of the exhibit that are extremely important, or highlight, or have experts, actively walking up to, whether it be, on a smart board or on a PowerPoint, pointing to certain things and being like that professor that is teaching the class and just being as active as possible. I think, sometimes if you've got an expert on the stand and they're there for a long time, if they can move around a little bit and, be a little bit animated and even just the standing and pointing, I think can be extremely helpful by using technology.
Yeah, the technology is just really useful in understanding that human beings process a lot of stuff visually, particularly, people who don't understand the coming in, the subject matter of something. And the technologically, you can present that kind of stuff. You can highlight, information in an email exchange that the expert found important, or you can, do the PowerPoint where, you try to make sure that you have comparatively few words on each page, and other visual cues that can help the processing of the claim. And the videos are useful as well. There's a lot of stuff that can be put into that, and you can, people. It's a different world. People watch 6-minute YouTube videos. They don't want a 4-hour lecture on something. They process things in smaller bits, and you have to take that into account. Who your audience is, and how things will be understood.
So it sounds like both of you kind of think that demonstrative evidence is the most helpful with lay people. Is that fair to say?
I think it's very important to in today's day and age to use demonstratives. As Bob was saying, people, especially younger people, are used to seeing things on a screen. But I think there's also, I think if you can, it's also a good idea to have certain documents, in the hands of jurors. And, I've seen situations where every juror gets a binder. And, sometimes, it gets to a point too, if you're looking at the screen too much, you just kind of feel more comfortable with that, knowing you've got the backup of a piece of paper that you can refer to. If your vision, your eyes are getting blurry from looking at the screen for so long, you just want to take a break, or if you just kind of want to touch and feel it, the document is there. But one thing I would caution is whether you're using demonstratives, PowerPoint technology, binder, whatever it is, it's always good, well in advance of the trial to clear it with the judge, clear it with defense counsel, make sure that that's all ready to go and there's not going to be any objections or any concerns, before trial.
It actually touches on the very next trial tip, which is to give it to the jury in writing rather than on a screen, given that, sometimes it can be very tiring to stare at computer screens all day. And I certainly prefer to have a stack of papers in front of me every now and then. So,
yeah. I think just using both has been the most effective way to go. I think, that I've observed, you having the screen and having the binders. I'm sorry, Bob.
Oh, sorry, Steve. Yeah, there's interesting studies going on about what sinks in best and when people process information better when they have something in their hands, and when the screen is the better way to do it. I think that antitrust cases are complicated enough that you want something that they can hold in their hands, and that you don't want them to have to remember all the things that were on the screen during the trial. You want them to have the ammunition to make their point, that if you're going forward and they're deliberating, you want to give them the ammunition so that they can make their points and maybe persuade some of the other jurors. So I think that putting things in it's something that there are some people that thought we wouldn't need to do that anymore. I think it's pretty clear that we really do definitely need to do that still, to do demonstratives, to put it in their hand, to go to the level of detail that is sometimes necessary to prove your case.
And I think one thing we talked about during the prep call was eyesight, which I hadn't thought about, but some people it may just be easier for them to have a document in their hand than to be looking up at a screen.
Yeah, absolutely.
And I think it kind of depends on the type of learner you are. Some people are more visual, some are more auditory learners. So I think it really depends on just how you interpret information and process it as well.
Right. And I mean, one thing that I try to remember is that when I am at home, I almost always put the captions on when I'm watching TV. And does that mean that I'm an old guy? Yeah. Does it mean that it helps me to process it? Yeah. And other things. And I think that you sort of have to keep that in mind, that that you have to make it accessible to everybody, the judge, the jury, other people in the room.
I was going to add one practical tip about using the binders, and sometimes this is with the help of a judge. Have the judge instruct the jurors, but you want to make sure that they're only looking at the binders, that the documents that you're referring to, and not flipping ahead, not flipping back. You obviously want to keep their attention, because that's one concern with the binders is the jurors have a tendency to flip all over the place, and then they're not paying attention. And a judge may also be concerned about if the document's not in evidence yet. Obviously, don't want the juror to look at it. So, just one thing to keep in mind from a practical point of view, you have to be able to address that issue.
And have either of you ever encountered a situation where demonstrative evidence of some sort has actually hurt your presentation at trial rather than helped?
I certainly think it could be overdone. Yeah. I think you can do too much of it. The problem sometimes with relying on too much technology is you're not making that connection with the jurors. You want to be able to speak to them. So, and at some point, jurors do, like we said, just get tired of looking at the screen or looking at a document. So, this is really more art than science. I mean, there's no way to really say exactly where the line is drawn, but I definitely think it can be overdone, and it can be used sometimes. If you use too much of a crutch, and you kind of lose that connection with the jurors. So I think you got to find that balance somewhere. Where that balance is, I think it depends on the lawyer, the expert, and the particular case.
Yeah, no, there's definitely a challenge as a state enforcer. We don't do the hardcore graphics that you'll see some of these defense firms do and otherwise. And there's some benefits to that. There's some detriments to that, and you sort of have to go with what you are. But there are times when I thought that we maybe didn't do enough of it, and when the defense counsel did way too much. It's more an art as a science than, as Steve says. But you should be thinking about that kind of stuff.
I went up against a defense lawyer a few years ago, who was he's very experienced. He was proud of the fact that he said, I've never turned on a computer. I don't even know how to use one. But he was extremely effective with the jury. I mean, he made no bones about it. Like, technology wasn't his thing, but he was extremely comfortable, talking to the jury, looking at them, making the connection. So, like I said, you got to find that balance.
So I think that does bring us to our next trial tip, and to really consider your audience and catering your expert testimony to appeal to that audience, given that a jury in one state may be very different from a jury in another. So, Bob, Steve, why don't you tell us about what considerations about demographics of your jury and how that affects your preparation for your.
I would say the one thing that you can really do there, if you have the resources, is to do get a mock jury of jurors that live in the district that you're going to have your trial in front of. That's how you can really get a sense, because you're really talking to the people that are coming from that geographic area. That's obviously not always easily done. It takes a lot of money. So I think bearing that, I think it's it's difficult to really predict what a jury in California is going to be versus a jury in New York in terms of reacting to experts. So I think one thing is, I think it's always good for experts or any witness, when they're explaining something, to use examples. Easily explainable examples are always helpful. So, I mean, just a small tip, something I might do if I were the lawyer or working with the witness is, I mean, again, to humanize them, just throwing out an example. I mean, we'd have to think about this more carefully when we're in a specific jurisdiction. But let's just say, you feel like you're in Los Angeles and maybe you got a lot of, basketball fans, and you can like maybe throw out the Lakers as an example. Or if you're in New York and, it's in the midst of the playoffs and you think you got a lot of, possible Knicks fans on the jury, maybe, have the expert use some example that, he's throwing out the Knicks. Again, I know a lot of people are not sports fans. It's just something that jumped to mind. You have to spend some time thinking on it about it. But, I think that's something you could do to, capture the jury's attention more and humanize the expert. And I would say the other big factor here, and maybe Bob will touch on this too, there's a big difference between obviously a bench trial and a jury trial. With a bench trial, you may be able to move along a little quicker. Judge is going to handle the trial a little bit differently. I think in both cases, you still have to explain economic concepts in a simple way. But the one thing I think you may want to prepare your expert for in a bench trial, it's not going to happen in a jury trial, is, you very well may have a judge himself, asking questions of the expert to kind of move things along. So I would want to prepare the expert to be ready for that and not to get rattled by it.
So do you do a mock trial with the expert?
I think I think it's, if you can, it's worth it to do a mock, not necessarily, a trial, but a mock exercise where people from the outside who are not part of the trial team can give you comments, because, what's clear to us as lawyers and people working on the case may not be so clear to a third party. So to the extent you can get somebody from the outside in a mock situation, I think it's always helpful. And that, that goes with any kind of witness.
Yeah, I think that's an important point.
There are certainly challenges there, and mocks are certainly very useful. They get you out of your silos, so you tend to talk with antitrust lawyers most of your working day, and it's good to get out of that and sort of plan it accordingly. Voir dires are interesting too. You sort of learn what these people, where they come from, what matters to them, and other things like that. And it's useful to try to think about, the other experiences that human beings have and how you have to meet all of those. A mock is a very good way to do that. It's been embarrassing for me sometimes to realize how much I become siloed before you have those mocks. So,
yeah, I do think that's a very important point, given that, we as practitioners and our experts, oftentimes we might be working on a case for years on end, and we might focus on certain issues more than others, but having a mock jury come in, people who are not as familiar with the case tell you what really matters to them, can be very eye-opening and really refocus something for trial.
Right. One anecdote I often tell is that I have been deposed a couple times, and I think that it's given me an insight to the failures of memory and, the passage of time and other things that some of my colleagues don't have that I think I have, because I was under oath and I was asked, they had been looking at documents that I really hadn't been focused on. And, it's interesting. And that whole thing, getting out of your silo, is a useful thing to think about.
I have a question piggybacking off of, Stephen, your comment on perhaps sometimes a judge will question the expert themselves. If your expert doesn't particularly know the correct answer to the judge's questions, how do you kind of keep their credibility to the jury?
Yeah, I think that's a very good question. So I think, again, everything we're talking about goes back to preparation. So I think, you have to prepare your witness to say, listen, if you're hit with a question that you don't know the answer to, just be upfront about it. Just say you don't know. The last thing you want to do is start inventing some answer that doesn't come across as credible, or that could be, easily cross-examined. So at the end of the day, I think, like any other witness, if, just if you're on cross-examination, or if a judge is asking you the question, whoever it is, just give your best, most honest answer to that question. And there's always an opportunity for for the lawyer who did the direct to get an opportunity, hopefully on redirect, to clarify.
Right. It's always my view is that you have to have your expert comfortable to talk about what he or she thinks is true and answer questions, and not be worried about what he or she thinks you want them to say. And you deal with what their testimony is, instead of the more you try to scrunch it into your expectations, the more trouble I think you get into. You have to sort of believe in your case, and that, you've discussed all the nitty gritty in the preparation, and judges ask good questions often. And, you have to deal with that.
So I think that's the perfect segue into our last trial tip, that's to be aware of the pitfalls or weaknesses of your expert. I mean, I think Bob, Steve, you were both touching on this a little bit. For example, an expert opinion is what the expert's opinion is. Being aware with that, it may not be the most ideal for your case, but how to work with it and how to really weave that for your benefit at trial is an effective trial skill. So, how important is it to be proactive about defanging, for example, the biggest criticisms your expert might have at trial in your direct, as opposed to waiting to rehabilitate them on redirect?
Yeah, I'll let Bob go, shortly, but I think I'm strong advocate for get it out front, get it, defang it before the defense. I'm prosecutors, I'm always thinking defense, but before the other side does it on cross-examination. I mean, at least if you do it that way, it helps the credibility of the expert witness. I think if you save it for a cross, it looks like you and the expert are hiding something. So, I would take this thing out of it on direct.
Right. I'm a pretty big advocate of if there's a big problem in your case, you ought to find it, and maybe, like the prosecutors can be thorough enough to make sure that those problems aren't there. If they're identified by defense counsel, and you don't have a response to it, that's pretty bad. You ought to prepare to know that where the pitfalls are. You've thought about those issues. You've thought about how defense counsel is going to present things. You know the kind of things they might focus on, and you should have a good response to that. And it should be completely forthcoming. And if there is a problem with your case that you can be done in on a cross, I mean, you really ought to know that long before that cross happens, or else you're not probing enough.
I was going to say, address it, in a similar way you would, let's say, if you're writing a brief. I think we're all taught, right? You want to put in, if there's some cases that hurt you, bring them out, bring them to the attention of the court, and then explain why, those are not fatal, or, what the, why they don't hurt you as much as they can, or they could, or just, give that response, which if you're submitting a brief, you don't want the other side to come in, with their reply brief, and, ripping into your cases before you've had a chance to, acknowledge that they're a problem. So I would approach the expert witness testimony the same way.
Right. And as a matter of fact, not only is it not bad for your case, but there are parts of that case that help you. And, that is part of the process of making sure that the expert opinion has considered all the alternatives and, other things, that you can transform that sword into a shield and maybe back into a sword. So,
yeah,
right.
That's right.
And I think that does do a lot for an expert's credibility to say that, I have considered all these criticisms that the other side has levied against me. And, really, it further confirms my opinion rather than detracts from it.
So many useful pointers in here. Kathleen, I was trying to write them down as we went, but can you recap our 7 tips for our listeners?
Yeah, sure. So tip number 1 is that reps and experts are very important. Tip number 2 is to humanize your expert. Tip number 3 is to let your expert tell a story rather than having things be in scientific fashion. Tip number 4 is to cut to the important part of a stack of documents. Tip number 5 is to give it to the jury in writing rather than just on screen. Tip number 6 is to consider your audience and cater to your expert's testimony to appeal to that specific audience. And our final tip, last but not least, is to be aware of the pitfalls or weaknesses of your expert.
Great practice pointers. So thank you, Chris, Kathleen, Steve, and Bob for this extremely informative episode. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.